right, good morning, everyone. My name is Donna Jones, and I am the manager here with Obsidian HR. I have Janet here joining me for today's webinar. A couple of things I wanted to share with all of you is that we are talking about wage and hour law. This will really basically entail federal law. We're going to make sure that we're covering all the federal laws. And in addition, though, we will from time to time mention state law. And because we are located in Colorado, Colorado is our focus, but we are happy to answer questions on other state laws and such. And if we're unable to answer your question live here, we will get back to you. So be sure and put all your questions in the Q&A option there on your screen. Everybody has the ability to unmute, so please do unmute if you also have questions. We have a lot to get through. So again, if we can utilize these functions well, then we'll get through everything and teach you guys a few things about wage and hour law along the way. So again, very excited to have everyone joining us today. It looks like a really great group, and Janet and I are excited to share this information with you. I'll let Janet introduce herself here.
Hello, everyone. My name is Janet. I have been with I have been with Obsidian for just a little bit over a year. However, I do have over 32 years of professional HR experience, with the majority of those in the corporate HR roles. So what I like most about my job is really getting to know our clients and helping them find ways to reach their goals and objectives. I also really enjoy helping others understand the why and the how behind many of the employment regulations. Rather than just telling them what the regulation is, I do think it's important that they understand the why and the how behind it. So, Donna, I'll pass it to you.
All right. And as I said, my name is Donna Jones, and I've been with Obsidian HR and our parent company, ProService Hawaii, since 2004. So um, I do have 30 plus years of HR experience, but the last 20 I have been in the PEO industry, which, PEO, HR for the PEO industry is kind of like on steroids. You get all these different situations all the time, and it is really helpful in the fact that we have, a vast variety of experiences within the team. What I like most about my job is just working with our clients and sharing my knowledge, helping people to understand, what employment decisions will help to keep them out of hot water and why. As Janet said, I believe that the why is really important. And part of our job here at Obsidian, when we are working with our clients, is as you are talking to us and telling us what you would like to do, we're going to analyze the risk involved in that and make sure that we're sharing that with you. So, of course, you make the decisions. We're not here to make decisions about your employees. That, of course, is it's your company. You have that opportunity to do so. But we want to make sure that you understand the risks involved in the employment decisions that you might make. And we're going to also talk to you about the laws that regard that, so that when you are considering those risks, you can really decide what's in the best interest of your organization. Because sometimes I'll tell you that it's worth the risk. So that will be, just some of the things that we assist our clients with on a day-to-day basis. So very happy to have everyone here, and we will go ahead and keep going.
All right. So again, today, as Donna said, we're going to be focusing on wage and hour laws, which is covered by the federal law under the Fair Labor Standards Act. We will be taking a look at how state laws may intertwine with federal laws as we go through the different topics. This presentation will be high-level overview of the rules. If you have specific questions that apply to your workplace or that we're not able to clarify during the presentation, please feel free to reach out to us, and also put your question in chat so that we can reach back out to you ahead of time as well.
All right. And oftentimes we think about wage and hour law, and it's like, well, yeah, sometimes, we're supposed to pay people overtime, or we're supposed to make sure that they get the wages that they're due, but why does it matter? And so, wanted to find some examples of why it matters. And this particular one is from California. It was two ice manufacturing companies. Now, I want to point out that this was a federal investigation, Federal Department of Labor investigation. So they looked at what was going on from a federal point of view. California has some very specific rules that pertain to their wage and hour law that were not taken into account here because this was a federal investigation. Okay. So, what was happening is that they were paying the employees straight time for all hours worked. So, they weren't paying them overtime. They weren't necessarily tracking hours all the time. They weren't giving, any sort of, well, I mean, and under federal law, breaks aren't required, but they weren't doing that as well. They ended up having to pay the companies, the two ice manufacturers that were related. All right. So I want to say that as well, because even though they were two separate manufacturing facilities, they had common ownership and therefore they were looked at together. Could have been two separate FEIN numbers. And oftentimes that is one of those misconceptions that if I own a business, I own, say, several restaurants, and each one has its own FEIN, then each one is separate. And the Department of Labor looks at common ownership, common management. Do you share staffs? Do you have everybody under like the same rules? Things like that will mean that the Department of Labor will view them as one company. And that's what happened here with these ice manufacturers. They were related, and so they viewed them as one. The total amount in damages was $527,000. Now, the Department of Labor doubled that. So they added liquidated damages, which doubles the amount in back due wages, and that money goes to those employees. The average here was around $15,000 to each employee. So pretty good little paycheck, right? Um, they also had 36, almost $40,000 in penalties. Now, let's say that the company said, oh, we're not going to pay that. Well, then it goes to court and it could potentially end up with, of course, higher fines, but an owner of an organization that is doing this type of activity, working people 16 hours a day without paying them overtime, they can end up spending time in jail. So again, this is worst case scenario. This is what can possibly happen. Recent situations, so I wanted to point this one out. And again, federal law, if they looked at state law, there would have been daily overtime due. There would have been meal breaks that were due and meal break penalties. So that, $1 million in back wages and damages could have potentially been much higher. Janet, you want to talk about this other situation?
Yeah, absolutely. This is one I found interesting because it's a lot closer to home for us here in Colorado. An employee, a former employee of Los Dos restaurant in 2023 sued the company and its owners, accusing them of not paying minimum wage or overtime, of splitting tips, and then, of course, not providing rest breaks, which Colorado does require. The lawsuit became a class action for Los Dos under the federal law, and it went back 7 years. So all records between 2017 and 2024 were reviewed, and the penalty and back wages resulted in $3.8 million in order to settle that class action lawsuit. And that's without even taking it to court. This was a settlement. Oftentimes when you go into a court case, it can become a much higher amount depending on the jury verdict. So this is why it matters. This is important that we understand why we want to do things correctly.
All right. And so I did notice that we had a couple of questions and I went ahead and answered those. So if you have any questions, please don't hesitate to put those in the Q&A mode. And let's get down to, what are some of those federal wage and hour laws? And so when you're thinking about whether or not the federal law applies or if state law applies, here are some things that you need to consider. Generally, for state wage and hour to apply, then that employer has to have one or more employee in the state. That state law is going to apply. So the place where they run their basic business. Now, when you have remote employees, where those remote employees work, that law is also going to apply. One or more employee within that state. Okay. Federal law is a little bit different. So federal law says you need to have two or more employees. And the federal law, again, is the Fair Labor Standards Act. Two or more employees, plus the business needs to have at least $500,000 in annual revenue. So this is not net profit, it is annual revenue. Okay. And businesses need to be engaged in interstate commerce. Now, interstate commerce means that you're doing business with people in other states. So, in the past, when I have been involved in Department of Labor audits, generally what they would ask for is an invoice from a company that you purchase something from that is located in another state. So, interstate commerce is really easy to apply to most everybody. And with that in mind, if you do have that 500,000 or more in annual revenue, then likely federal law is going to apply. Now, when it comes to some sort of concern brought forward, such as that employee that Janet had mentioned, the government looks at where is this best, who's best to investigate this. State law generally will investigate a situation. Federal law investigates the company. So when federal investigation is involved, they look at all aspects that relate to wage and hour. And so let me just go ahead and switch slides here, because those aspects are the minimum wage. Is everybody making at least minimum wage? And if it's a federal investigation, we're talking federal minimum wage. Are people properly classified as exempt or non-exempt? And are there any employees under the age of 18? And if so, what jobs are they doing and what hours are they working? So we're going to go into these three main points in much more detail here, as we're going through this. Now, again, if any questions, please let us know. So minimum wage, federal minimum wage is $7.25 an hour. We can all agree that that's pretty low. They talk regularly about increasing it, but it hasn't happened. $7.25 an hour. And there are some states that do have $7.25 an hour as the minimum wage. For tipped employees are those that are defined as people who regularly and customarily, based on the job that they're performing, receive at least $30 in tips per month. Really low threshold, right? Now, again, federal law, lower amounts. So under federal law, a tipped employee can earn as little as $2.13 an hour. Okay. Since we're in Colorado, we wanted to share Colorado's minimums. So under Colorado state minimum, again, hourly minimum wage statewide, it's $14.81. And then we have Denver with a much higher amount. Boulder has two separate, incorporated and unincorporated Boulder County. So different amounts for each of those areas in Boulder. And then Edgewater also has its own minimum wage. Tipped minimum wage is true for all of that as well. The state tipped workers can earn as much as or as little as $11.79 per hour. Now, you may be aware that just last week there was a bill signed into law with Governor Polis that he said this law allows these other cities that have the higher minimum wage to reduce the tipped minimum wage amount. Under Colorado law, the tipped minimum has to be no more than $3.02, 302, than the actual minimum wage. Okay. So what this law did was it is allowing for the tipped minimum to be more or lower than that 302 under the minimum for that area. That's really confusing. I hope that made sense. So it's an opportunity for restaurants, perhaps, who really was the restaurant industry is who really drove this into law. And the restaurant owners are just saying, hey, if we're in Denver, we can't afford to pay, 15.79 to the tipped employees who are earning a lot more than $3 per hour in tips. Which brings us to this tip credit. And, how does that work? So again, in Colorado, that amount is 302. Under federal law, it's a higher amount, right? So what they say is that in order to pay these tipped employees the tipped minimum wage, they must earn at least $3.02 per hour in tips so that their combined wage between their hourly rate and the amount they make in tips is at least the minimum wage for that area. So, should Denver decide that they're going to pay a lower tipped wage, this will still be true. So, let's say Denver decides, okay, we're not going to take it all the way from this $15 down to, 11, but we're going to say tipped employees can make $13 an hour. Well, now, and let's just go back a slide just to emphasize this a little bit more. If they Denver moved their tipped wage to $13 an hour, that means that employees must make at least $5.81 per hour in tips. And this is an hour. I mean, this is an average. It doesn't mean every hour they counting their tips to make sure. It's an average in order to pay them that $13. Okay. So kind of complicated, but wanted to just share with that. And just with a thumbs up, are there folks here that do have tipped employees? All right, I'm not seeing any thumbs up, so that's good. So that means what I'm going to do here on the tip sharing and tip pools is this will be in the, it is in the PowerPoint presentation, which you will get a copy of. And you are welcome to contact us if you have questions, but we're going to go ahead and skip that since it doesn't apply to anyone here in the audience. All right.
Perfect. Donna, thank you. And just for all of you out there, if you do have tipped employees, Donna is my expert go-to for information on that. So she has that regulation down. So let's go back to some of the basics of the Fair Labor Standards Act as well. Oftentimes you are going to hear people refer to somebody as being paid salary or hourly. Others assume if an individual is paid salary, they're exempt from overtime. FSLA, FLSA, recognizes exempt and non-exempt. They they do not have rules that designate somebody as salary, for example. So an individual is either going to be exempt or non-exempt. The key difference between the exempt and non-exempt is that non-exempt workers are entitled to certain protections under the law. And again, that's the federal law that sets the minimum wage and overtime requirements. And then also we have state laws that complicate or intertwine with those federal laws. So although the FLSA has evolved since 1938, one thing remains the same: employees must be classified correctly, or the employer will risk costly compliance violations. Being compliant also means abiding by state laws and even local laws, as you saw in the slide previously with the minimum for different cities. And a lot of states are having local minimum wage laws set as well. But it also provides, when the state law provides a greater benefit than the federal law, then the state law will apply. Um, so we're going to go through some of those examples here. But first, we're going to have a true or false. Please, if you want to do thumbs up for true, thumbs down for false, or just put it in the chat, feel free to do that. True or false? A non-exempt employee that is paid on an hourly basis must record all hours worked and must be paid overtime if the company policy allows for overtime and the supervisor pre-approves the overtime. Non-exempt employees are paid on an hourly basis, non-exempt employees are paid on an hourly basis and must record um, hours worked. And I'm getting a lot of thumbs up because I think um, I may have said that wrong. So we're going to read it one more time. Non-exempt employees are paid on an hourly basis. True. Must record all hours worked. True. Must be paid overtime only if the company policy allows overtime and the supervisor pre-approves it. So let's just look at that last one. Only if the company policy allows for overtime and the supervisor approves it. So if the company policy doesn't allow for overtime, but the employee still works it, they still have to be paid that overtime. So the answer to this question is false. And again, even if the company policy says you cannot work overtime, if they do work, a non-exempt employee does work overtime, you must pay them. After paying them, you can certainly then go back to your company policies and apply any disciplinary action that may be necessary to prevent that from happening again.
Yeah, so and that's really the key here, you guys. If there's a policy that says that overtime has to be approved in advance, then discipline the employee for not getting that approval, but do pay the overtime. And it could lead to termination, right? If they continue to work overtime without permission, but you are required to pay it. If it was worked, it must be paid. Yeah. Thanks, Janet.
Absolutely. So we're going to go into a little bit more detail on non-exempt. So for hourly, aka non-exempt staff, they must also record time worked. These are referred to as their daily time records, and these daily time records must be maintained. It's not, okay, payroll's over, we don't need these records anymore. These records must be maintained. This includes the daily clock in and clock out, any adjustments to the hours worked, including if there's auto deduction set up for lunch breaks. Whether you use an electronic time and attendance system, a punch clock, or a paper system, these records have to be available for at least 3 years for an audit for federal law and even longer for state laws sometimes. So Colorado, for example, requires 6 years. California requires 4 years. Our recommendation is to keep all those records for 7 years to ensure you have the records you need when you need them. They can be kept digitally, and the Department of Labor wants the employee to be aware of all manual adjustments that you make to their time records. So the best practice when you do make an adjustment to an employee's time record is to have something in writing signed by the employee that they're in agreement with that adjustment. Okay, so overtime.
And I'm
Go-
sorry, just real quick. I see that Tammy has her hand raised. Tammy, did you have a question? You can unmute. Nope, I guess not. Okay. All right. Sorry about that. Go ahead.
yeah. Overtime, going on to the next box there, overtime is due to hourly employees regardless of whether or not they're paid by piecework, by the hour, by the job, etc. So let me give you an example. So if you have a roofer and the individual is paid by the job, and let's just say they receive $100 per job, but the job for this individual is now going to take 12 hours. $100 is not going to get them to minimum wage for that daily rate. So even if they're paid by the job, they still have to meet those minimum requirements. And again, good practice is whether they're piecework or by the job, make sure that they're keeping a daily time record. Um, all hourly staff must track hours worked, and overtime applies if they work over 40. So 40.01 1 minute, or excuse me, 0.1 minute would be paid at overtime. Now, keep in mind, some states have more stringent overtime rules, such as 8 hours in a workday, or working more than 12 hours in a workday, or in a continuous shift, for example, in Colorado. These are considered, again, daily overtime rules that the state applies. There are also some states that require 1 day of rest for every work week. For example, Nevada, more than 8 hours within a 24-hour period has to be paid at overtime. And California requires double time work for work over 12 hours in any day and more than 8 hours on a seventh day uh, of consecutive work. So again, we have to take those state laws into consideration. There is an emphasis on worked more than 40 hours. So there's various scenarios, but oftentimes you're going to see sick pay and holiday pay, hours paid but not worked. Again, holiday, sick, vacation. Um, those generally, most companies don't apply those to the hours for overtime, and they don't have to. The federal and state laws apply only for hours worked. Okay, and not for hours paid. And I'm going to have you go to the next slide. There we go. All right, now let's talk about the exempt individuals. As of 1/1/2020, the minimum wage for salaried exempt went to 35,568. Um, and more recently, it was increased, and then it was pulled back and it went back to the original amounts there. Some states have higher exempt minimum wages. As a matter of fact, a lot of states have higher exempt minimum wages. California right now has the highest at 68,640 on an annual basis. Colorado, anybody working in Colorado as an exempt employee must make at least 56 hours, excuse me, $56,485 for the year. And did we have a question? Okay, I apologize. I thought I heard something. So this is an area in which we support our clients by confirming when minimum wage increases occurred to ensure our clients stay compliant. So again, the minimum wage increases not only affect the hourly employees in some cases, but they also affect our salaried employees. So we're going to keep our, our clients in compliance with those. So to be paid on an exempt basis, all three tests must be met. Salary level, salary basis, and the duties test. So with that, we have compensation cannot be reduced because of variations in quality or quantity of work performed, must be paid the full salary for any week in which the employee performs work, and it need not be paid for any work week when no work is performed. And then the third is the duties test. Each category has specific duties that must be met in order to qualify as exempt. Some states also have additional duties test. And again, this is where we really help our clients by making sure they're compliant with the state laws as well. And as we learned earlier, misclassification of workers can be incredibly costly.
Janet, somebody asked to say that again, so I'm not
Mhm.
sure, and that they just said that, so perhaps you can go over again the three tests and how that works.
Perfect. Yep. So
I didn't ask for all of it. I just wanted the dollar amount for Colorado.
yes, the dollar amount for Colorado is at 56,485.
The 485 is what I missed. Thank you.
Yeah, absolutely.
And the dollar
Can you
amount for
clarify?
California, can you say that again?
Yes, the dollar amount for California is $68,640. And absolutely, if you have questions about other states, put those in the chat or the Q&A, and we can get those for you as well.
Can you clarify really quick on the 56,485? Does that mean that when someone's annual wage equals that amount, they should be switched over to exempt, or can you kind of clarify that?
No. Yeah, absolutely. And we're going to go through some of those duties test on the next slides. So all of that's going to fall under number 3, duties test, in which each category has specific duties that must be met. So there are different categories of exempt employees. So we're going to cover each one of those in a little bit more detail because those pieces are critical to understanding.
Yeah.
Just because a person is at that salary doesn't mean that they're exempt.
Yeah. Yeah, that was a great question. Thank you for asking that because it is definitely something that can be really confusing. So it's like, well, if I'm paying them this much, why can't they be exempt? So, and that again is because of that duties test. All 3 of these tests has to be met.
All right. So we have 4 main exempt categories. These are ones that you've probably heard of often. So we have the executive, administrative, professional, and outside duties test. Um,
Outside sales.
excuse me, outside sales. Thank you. Outside sales is a common classification for individuals that do have salespeople. Please keep in mind that titles are not a consideration in classifying a worker as exempt. So by calling an individual an executive does not make them an exempt employee. Exemptions are based on job duties. They're not based on job descriptions. They're based on the duties that the individual is actually performing. All right, so on our next slide, the executive exemption. Primary duty must be in management. The principal, main, major, or most important duty of that employee performs. So management duty examples: interviewing, selecting, and training candidates, supervising employees. That includes evaluating, disciplining, adjusting their pay, setting work hours, handling complaints. Also, they are planning and apportioning work among their employees. They're determining processes and procedures for their department or business. They're providing safety and security, planning and controlling a budget, monitoring and implementing legal compliance measures. So generally, 50% of time should be spent on management duties that we talked about. Law does not require 50% as long as the primary duty is management.
And just to
Cons-
specify that the things that Janet listed there, those are just examples of the type of things that are considered to be management duties. So there can be additional tasks that are part of management, but just the idea is that this is not the same work as the people that they are supervising. And we really want to make sure that that is true. All right, sorry, Janet.
Yeah. So in construction, a working supervisor oftentimes swings a hammer right alongside the rest of the crew. His primary duty is not management. He may occasionally direct the work of others or train somebody, but on a typical day, the work is the same as all other staff. This individual should be paid on an hourly basis. Another good example is, for example, a manager at a fast food restaurant that spends a majority of their time on the line working alongside the employees, and again, occasionally directs the work of others or trains, but most of the time is spent on the line with the other staff. They should be paid on an hourly basis. Um, they must regularly direct the work of 2 or more full-time employees. Now, of course, being the federal government, they've complicated this term a little bit, but this means 80 hours or more per week. It can be 4 part-time employees or it can be 2 full-time employees, but they must regularly direct the work of 2 or more employees. Overtime is not taken into account for this. If 2 supervisors share employees, the employee can only be counted under 1 supervisor. They cannot be counted twice, once under each supervisor. The individual also has to have the authority to hire and fire other employees or make recommendations as to the hiring, firing, advancement, promotion, and any other change of status that that is deemed appropriate. Many companies only allow the final decision to be made by the owner or the executive level staff as long as the recommendations are taken into account and given weight. The supervisor may still qualify under the requirement. If the supervisor has no say in the hiring, firing, promoting, etc., then they are unlikely, very unlikely to qualify as exempt under that category. And then our other category is the ownership. So someone that is an active owner, actively engaged in the management of the business and owns at least 20% of the company can be paid under this exempt status with no minimum wage. An owner's spouse that does the bookkeeping for the company that can be paid as an exempt only if he or she also owns 20% of the company. Now let's talk about that ownership. What that means is, because there's another little piece in there that says and no minimum wage. So an individual that is an owner of a business of at least 20% can be paid under the exempt status with no minimum wage. There is no requirement to hit that 56,000 in Colorado, for example. They can be paid less, but they have to have proof of ownership of more than 20%. All right, actively confusing. That was our executive exemption test. Now we have our administrative exemption test. And this is one where we see the most challenges for our clients, right? So the primary duty, excuse me, um, it gets very murky and it's harder to meet the qualifications. And again, it's the most commonly misunderstood classification. So the second bullet point on there, exercise discretion and independent judgment with significant matters. So the more task-oriented the job is, the less likely it's going to qualify as exempt. So let's look at this a little bit further, make sure we understand what it means. The Department of Labor says that some of the factors they look at include, but are not limited to, the authority to formulate, affect, interpret, implement policies. Are they able to carry out major assignments in conducting the operations of the business? Do they perform work that affects business operations to a substantial degree? Do they have the authority to commit the employer in matters that have significant financial impact? And are they involved in the planning, short and long-term business objectives? Do they have the authority to negotiate and bind the company into significant matters? And do they provide consultation or expert advice to management? So an office manager, somebody that's deemed an office manager, may not have this authority and therefore would not be exempt. Let's talk about another example. A project manager is another one that we see often misclassified. A project manager can do a lot of things, filing bids, they could be scheduling dates, processing, or on the other side, they could be meeting with vendors, negotiating prices and terms, entering into agreements on behalf of the company. So you can have a great job description or a great job title, but it's not that matters, whether you're exempt or non-exempt. It's about the actual work that's being performed by the individual. Another good example that we see oftentimes is bookkeeper versus staff accountant or accounting clerk sometimes will be used and still given an exempt status. And again, we're going to look at what the individual is actually doing. Are they just recording the ins and outs, keeping track of things, billing the clients, etc.? Or do they have more meat in the game, which includes issuing the payments and independent discretion and judgment? So these can be quite complicated, and this is where we like to help you understand that piece a little bit more. All right, everyone, we're going to go ahead and move on to our next slide. So question for the group, administrative exemption. Would a comparison shopper or a store buyer qualify for the administrative exemption? And in the essence of time, I'm going to go ahead and provide the answer here. So a comparison shopper performed by an employee of a retail store who merely reports to the buyer the prices at a competitor's store does not qualify for the administrative exemption. However, the buyer who evaluates such reports on competitors' prices to set the employer's prices generally will meet the duties requirement of the administrative exemption. Now we're going to move on to the next exemption, which is the professional exemption. Now keep in mind there are two professional exemptions. One is going to be the learned profession, and the other one is going to be the creative profession. Learned professionals performing work that requires advanced degree, typically 4 years or longer. Now, these examples would be doctor, lawyer, chef, corporate trainer. Keep in mind, having the 4-year degree does not automatically qualify a person for this learned professional exemption. And then moving on to the creative professional exemption. This individual is innovative, they're creative, they're artistic in nature. So just kind of giving you some examples. A reporter on a high school sports team, no, that work would probably be too routine, but a blog writer who writes on the fun things to do in Colorado, that one probably would qualify for that creative professional. Additional professionals would be actors, novelists, songwriters, rock stars. Another example, journalists would not qualify for the creative professional. They are giving a topic and parameters, such as number of words or things they can and cannot say, but a novelist would qualify. Another example is a dancer versus a choreographer. The dancer can be taught the moves, but a choreographer creates the moves. So the choreographer would qualify for that creative professional exemption. Now we're going to move on to the outside sales exemption. A good rule of thumb is that an individual needs to be engaged in work away from the primary place of business at least 80% of the time. The intent is that these salespeople are out and about meeting with existing customers for new orders or seeking out new customers. Recent rulings regarding this exemption have stated that home offices are not outside sales because they're not outside the primary place of business. Cold calling from home would not qualify an individual for this outside sales exemption. And then now we're going to talk about pay docking. We're going to think back to the prior 3 tests that we talked about. We have administrative, executive, learned profession, and one of them is the salary basis test. The employer cannot make changes to wages based on quality or quantity of work performed. So if somebody is not performing up to par, again, you need to follow that disciplinary process for that versus docking any of their pay. And there are 7 exceptions to the no docking payroll. You are not allowed to deduct pay when the reason for the absence is contributed to the employer. This is why many organizations rely on management team to handle the business when there is a hurricane or flooding, or just when you need to shut down for a day or for some reason. And okay, when the exempt employee is absent for work for one or more full days for a personal reason other than sickness or disability, vacation.
I'm sorry, I'm so lost. I'm so sorry, Janet.
Yeah, we're going to be on 24.
Okay.
So the 7 exemptions to not docking pay is when an exempt employee is absent from work for one or more full days for personal reasons, provided no work is performed. Number 2 is for absences of one or more full days occasioned by sickness or disability. Work-related accidents if the deduction is made in accordance with a bona fide plan, policy, or practice of providing compensation for loss of salary, sick leave, PTO, work comp, etc. These are going to be those policies. Number 3, while an employer cannot make deductions from pay for absences of an exempt employee for duty attendance or attendance as a witness, temporary military leave, etc., an employer can offset the amounts from jury fees, witness fees, or military pay. Next slide, number 4. Another exception to the no docking pay is for penalties imposed in good faith for infractions of major safety rules, and that word major should be capitalized. So if somebody is suspended for major safety violations, for example, you would be able to dock pay. Number 5, for unpaid disciplinary suspensions of one or more full days. And number 6, for any time not actually worked during the first or the last week of employment. So if you have an exempt employee, for example, that ends their employment on a Wednesday, you only need to pay them through Wednesday. You do not need to pay them for the full week. And number 7, for any time that is taken under unpaid family, FMLA, or other protected leaves by the state. So you can still dock pay for any time taken under those entitlements.
And Janet, can I just clarify real quick on number 4?
Please.
So when there's an investigation happening and we don't know if there was a rules violation, you can't dock their pay. They would have to be on paid suspension or paid administrative leave. I prefer administrative leave. Suspension infers that there was something was wrong, something was done wrong. So paid administrative leave is generally the terminology. Again, this is for exempt employees. And then once that investigation is done, if there was found to be wrongdoing, that's when you can put them on that unpaid suspension or leave. Yeah, just to clarify that. All right, so child labor is one of those areas that is, very particular. And I just want to, before we go through all this, I want to ask if you can give me a thumbs up if you hire individuals that are under the age of 18. Okay, so it looks like there's maybe a couple of folks that do so. So there are some very specific rules. And again, child labor is covered under both federal and state requirements. For 14 and 15-year-olds, it's split into 2 groups, 14 and 15-year-olds, 16 and 17. Some states don't allow people to work until they turn 16. Other states allow that younger age. Generally, there's a requirement for either a work permit or an age certificate type thing to show that the individual is of the age required. The younger group, a lot of restrictions on hours. During the school year, there's no more than 3 hours a day, not before 7 a.m. or 7 p.m. Again, this is federal law, so you'd have to also confirm your state law requirements. Once the individual turns 16, then under the federal law, they lift those requirements as far as restrictions on hours. But there are, for both groups, there is a long list of what they consider to be hazardous duties. that those minors are not allowed to perform. Now, 14 and 15-year-olds, these are the only group under federal law that is required to get a meal break, a 30-minute meal break or a 30-minute break after 5 consecutive hours. So again, that's under federal law. These are the only folks that you're required to give a break to. So, we're running low on time, and again, I apologize for the disruption where my system went down for a moment, but just quick information here. And if you have more specific child labor, minor employment type questions, please let us know. Just a couple examples here on Colorado and the variations between Colorado and federal law and which would apply. Okay, so that's there on the left-hand side. On the right-hand side, Colorado does not allow anyone to work, with the selling, dispensing of serving of alcohol. They can bus tables and remove empty containers, and then they're not allowed to work in the marijuana industry. So those are some specific industries that Colorado has earmarked. Now, again, we're running a little low on time, but we do have a little bit of information here that we'd love to share about your hourly non-exempt employees and when wages are due. Okay, Janet? You're on mute.
We're going to go to the next slide, Donna, where it
All
talks
right.
about those in a little bit more detail. So again, we're talking about your
Perfect.
non-exempt employees and when wages are due. So if they're suffered or permitted to work, so if work was performed that was not requested, but it was allowed, wages will be due. Employees must be paid anytime work is performed. On-call or waiting time, this is oftentimes a very confusing topic with our clients. So it must be paid if the employee must stay on premises and they must be ready to work. So they're constrained maybe by their travel. Their time is controlled by the employer. They do not have to be paid if the employee can use time for their own personal reasons. So they can come back to work when they need to. They can be on call, but don't have to actually do anything until until they deem that until they deem it's appropriate, basically. So, such as something needs to be fixed, but it doesn't need to be fixed right away. So, for example, they can come in whenever. Travel time is another confusing topic for our clients. Time spent in commute is not paid to and from the office, for example. Travel that occurs at an employer's request, such as going from one work site to another, running errands, must be paid. And we're going to go to the next one, training time. This is a very common one. Training time needs to be paid or doesn't need to be paid when the attendance is voluntary. If it's not work related, it is outside regular work hours and no productive work is performed. If attendance is mandatory, if it is work related, if it's during work hours, or even after work hours, if it is required, they do have to be paid. And then we have compensatory time. Compensatory time, please, is one of those terms that are most often used in the public sector and not the private sector. And by using compensatory time, what you're doing is you're making an individual who is supposedly exempt to have to keep track of their time. Once you have an individual keeping track of their time worked, you risk the chance of that position no longer being exempt from overtime. So we caution our clients to use this. However, it can be used provided an individual is not having to track their time and report, well, I worked 4 extra hours this day, but instead they're giving they're given a comp day, for example, in the future to be used. In order to do this, however, you do have to have a policy in place. And then we're not going to take time for the answers on this. We'll go ahead and answer. True or false, if an hourly employee is if quickly work on, now I can't even talk. If you ask an hourly employee to quickly work on something during their break, they do not need to be paid, even if it just took them about 3 minutes. And the answer to that question is false. If an individual is working, they must be paid. And this would be a break such as a lunch break that's 30 minutes long.
Yeah. And if that break is interrupted and they're made to work, the entire break has to be paid. Okay. A couple other quick things here. Deductions, wrongful withholding and deductions. Anytime you're taking money from somebody's paycheck, unless it's a statutory deduction, such as healthcare benefits, taxes, of course, or even like the garnishment, those are allowed to be done without written authorization from the employee. But if you are taking other deductions from an employee's paycheck, best practice is to get that in writing and payroll deduction authorization form. Any deduction cannot move that employee to below minimum wage. So let's say that somebody had a loan and you're trying to take the balance of that loan from a final check, and it's going to take the entire check. You have to allow them at least to have minimum wage for the hours that were worked, right? And I think we all understand that at that time that somebody is separated from employment, that you really do have to follow final pay rules. When are wages due? Many states require payment of wages at the time of termination or very quickly afterwards, although under federal law, wages are due on the next regular payday. So,
Yeah, and I just want to add to that also real quick is that states also have regulations if you're going to take wages from their take money from their final wages, which includes, for example, making sure that they're notified in advance if this isn't returned, your wages will be docked. So there are other state requirements regarding the final payment of wages that come into play. Okay, so our takeaways: ensure staff are classified correctly, and really for everyone that's out there, if you have questions, please reach out to us. We love to help you. If make sure violations of FSLA, violations of FLSA can result in back wages and penalties. And again, those back wages are going to go back 7 years. And then also contact your HR consultant with questions, and that would be us. So again, I can't thank everyone enough for their time. Are there any questions that we are leaving you with?
so there is a question here from Robert. He says, can you include some of the final pay regulations when you send the slides? So we can look and see how we can best do that to provide when final pay is required by the various states. So sure, we can do that, Robert. And thank you all so much for your time. I know it was a quick hour, and you can reach Janet or I at help@obsidianhr.com. And we would love to hear from you with any questions that you might have. Please watch for a copy of today's recording along with a copy of the slides to be sent to you via email. Thanks so much. Have a
Thank you,
great day.
everyone. Appreciate your time.